Stephen Sheldon with SMS Capital Management. In an effort to help you make sound and practical decisions when it comes to managing your wealth, I'm conducting a series of short video interviews with other professionals on a variety of topics that may impact you. So I'm here today with Paul Strug, who is a board-certified attorney in probate and estate planning.
Correct.
And Paul, most of his work is done for preparing for when we're no longer here. And Paul, most people are familiar with a will, but why don't you tell us a little bit, what is the importance of estate planning?
Well, really, there's three primary considerations. I think one is really the goal of having the client be able to dispose of his or her property as he or she deems appropriate. And most effective way to do so is through a will. Secondly is providing for certain situations. Maybe it's minor children and structuring how they might inherit. Maybe it's an adult child that has some special needs and having some very specific requirements. Maybe it's a family business passing down to two adult children to try to prevent infighting and family disputes. And again, using the will as part of the estate plan as a way to accomplish that. And then the third would be doing so in a tax-efficient, tax-friendly manner. Try to avoid, if not eliminate, the exposure to the federal estate and gift tax.
So once you have will and estate documents in place, how often would you recommend that people review that?
Generally, I say to clients every 2 to 5 years, just a general review. Make sure everything's moving along as they've planned with respect to their assets. Additionally, naming the trustees or guardians might change over time, and so that's a good opportunity to do so. And then I also encourage clients on life events. Either they've inherited some assets that, we need to incorporate into the planning. They've had additional children we need to bring into the fold. A divorce is obviously a situation that's going to change planning. So life events are triggers to come in more frequently if they happen, but otherwise I suggest every 2 to 5 years.
So let's talk for a second about, now that you've spent all the time thinking about having the right set of documents in estate planning, where do you keep all these documents? Everybody seems to think you need to keep it, safe, locked in a safety deposit box. Is that a good idea?
Well, with the wills, it is good to keep the originals somewhere safe because the originals have the legal import. But the old school mentality of just putting them in a safe deposit box, this day and age, someone else needs to have access to the safe deposit box. Because if husband and wife die, and child says, well, I'm named as executor, well, if they're not on the safe deposit box, it's going to be difficult for them to get into it to pull out the original will.
So what are some more practical solutions then?
I mean, that can be a practical solution, again, as long as someone else is on there. A safe in the house I have clients utilize.
As long as somebody else would know, a child or somebody
a combination.
Would know how to get into that.
Exactly. Others is many law offices, lawyers who prepare wills, offer will vaults where they'll store the original wills and keep them under lock and key. We do that at our firm as well.
What about in digital format? Is there an issue with keeping online in a secure vault?
So for copies, many times clients will use whether it's an online secure vault, such as what I believe you offer to your clients. Some clients will put digital copies on a flash card or some type of portable USB device, and they would tell their children, something happens to us, this is in the drawer in our study. Something where someone can access it and take action. Because all the planning in the world doesn't do any good if the next people in line to help carry out your wishes have no idea where to start or find the documents.
And is a copy good enough in the event that you need it, or does it have to be an original?
So with a will, it is strongly preferred that it's an original. The probate code, estates code does allow for a copy, but the testimony and the bar to entry is much higher. With the other documents, the medical power of attorney, the financial power of attorney, you might present someone an original, but almost always you're just going to give a copy.
Okay.